Tell them that you would like to speak to an attorney with respect to the information that you are providing, and say, after I speak with my attorney, they will be in touch with you. Don't promise that you will talk to them later, because they're going to be writing everything down that's going to be in a report. And then there will become a time in which, if you decide not to talk to them later, that very well you might be confronted with your promise. Don't explain your reasons, but always say, I want to delay this conversation while I speak with an attorney. Your invocation of counsel cannot be later used against you. You have a right to speak to an attorney. Politely declining the request to interview by invoking counsel is not the same as remaining completely silent and saying, I don't want to talk to you, I'll get back to you later. That can be used against you later on. That might be used to demonstrate a consciousness of guilt. And when I say you, I'm talking not to you collectively as attorneys, but because of the clients that you represent, the corporate officers, the people who they really want to talk to. But I will get back to that in a minute, because sometimes the FBI wants to talk to you too. There are some cases in which it's going to be in your best interest to talk with federal officials or state officials that are doing criminal investigations. Like I said, there are some industries in which you must. And there's a whole body of law that deals with whether or not you are immune from statements you are compelled to make in those circumstances. And quite frankly, like everything else in our profession, it's not very clear. It's pretty darn fuzzy as to whether or not simply because you're compelled to talk, it can't be used against you. But there are some cases where it is a compromise of your legal interest to speak with federal agents, even with an attorney. Martha Stewart lied with her attorney sitting next to her during interviews that took place at the U.S. Attorney's Office. It really is important to be able to understand what the investigation is about, who the potential targets are, and what the individual roles may be with respect to the witnesses in the investigation before a decision is made. Your interview, your conversation is in a vacuum. But there are certain things that you can do in order to elicit information which will help you make a decision as to what to do. Now, let me step back for a minute. When I say you, all of you here are corporate counsel. And all of you are going to be asked by the people you work for and the officers and your bosses, what should I do? And you're going to be starting to give advice because you are the people that they're going to be coming to. One of the things you have to consider, and we're going to talk about conflicts of interest a little bit later, is whether you are going to be a better witness or a better advocate with respect to the subject matter that is being investigated by the FBI or the SEC. I'm a defense attorney now. What I would prefer, if I'm putting a witness on the stand, is to have one of you guys be the witness. Because you, in your relationship as a corporate attorney and in your functions as corporate attorneys, kind of straddle the attorney role and the administrative role. And so that's something to consider before you make a decision whether or not you are going to be doing the investigation. You are going to be the first person that's going to be there when search warrants are issued. The next thing that's going to happen is that the next day, you're going to get a grand jury subpoena for the same documents that the search warrant is asking for. Well, why would you do that? Why would the U.S. attorneys do that? Is because during the execution of a search warrant, the FBI may not find the information that they're looking for. So they're going to issue a search warrant to you, which you'll see in your materials. I provided an example. We'll talk about it later. Is going to list a gazillion things that are going to be asked for by the U.S. Attorney's Office. And there is your hook. Because what you want to do is to call the assistant U.S. attorney who issued the search warrant and say to her or say to him, this is a lot of material. I don't know whether I can get it all to you by the time that you want it. Can you triage this with me? What is it that you want first? And if you get an answer to that, you're going to get into the head of the U.S. attorney as to what they're really looking for. What is it that they want first? And in the case that I was dealing with, my conversation was, I want personnel files, I want expense files of people who deal with GE Capital. I also think that down the road, I'm going to want to see wire transfers. So now I have information from the U.S. attorney as to what it is that they want. And I try to engage a conversation as to what this is really about. Who are your targets? Who in the corporation can I speak to and not deal or violate any issues concerning conflicts of interest? Now, the Department of Justice has issued a memorandum to all U.S. attorneys and prosecuting agencies concerning principles of federal prosecution of corporate entities. This is the Bible by which the U.S. attorneys' offices throughout the country make a decision as to whether or not a corporate entity is going to be prosecuted. Because that is the real issue here. Remember I asked who you're representing? You're representing the corporation. You know, it very well may be that the president and the vice president and a few other people that you know and have lunch with will go to jail. But your obligation is to the corporate entity. And so that you need to know what the U.S. Attorney's Office is thinking about with respect to the prosecution of a corporate entity. This is an internal document that Justice Department lawyers use to make their internal decisions as to who to prosecute. The memorandum starts off by saying that the prosecution of corporate crime is a high priority for the Department of Justice. Federal prosecutors and corporate leaders share a common goal. Directors and officers owe a fiduciary duty to a corporation's shareholders, who are the corporation's true owners. And they owe duties of honest dealing to the investing public in connection with the corporation's regulatory filings and public statements. The faithful execution of these duties by corporate leadership serves the same values in promoting public trust and confidence that our criminal prosecutions are designed to serve. Charging a corporation. The general principle is corporations should not be treated leniently because of their artificial nature, nor should they be subject to harsher treatment. The paradigm is, and if you're defending the corporation, you have to change that. You want to demonstrate that the corporate entity should not be prosecuted. Indicting corporations for wrongdoing enables the government to address and be a force of positive change for corporate culture, to alter corporate behavior and prevent discovery and punish white-collar crime. First and foremost, this memorandum says that prosecutors should be aware of the important public benefits that might flow from indicting a corporation in appropriate cases. For instance, corporations are likely to take immediate remedial steps when one is indicted for criminal conduct. A corporate indictment may result in specific deterrence by changing the culture of the indicted corporation and the behavior of employees. It may very well change what is pervasive within an industry by focusing on one corporation with respect to criminal conduct. And finally, certain crimes carry with them a substantial risk of great harm to the general public, such as environmental crimes or financial frauds, which by their very nature are likely to be committed by businesses. And therefore, there may be a significant interest in indicting the corporation. The paradigm is indict the corporation. You need to change that paradigm. Now, under the doctrine of respondeat superior, a corporation may be held criminally liable for the illegal acts of its directors, officers, employees, and agents. And to hold a corporation liable for these actions, the government must establish that the corporate agent's actions were within the scope of his duties and intended, at least in part, to benefit the corporation. Those are the elements. Those are what they're looking for to determine whether or not a corporation can be indicted for the conduct of its officers, employees, and agents. Now, here's what the Justice Department says. In all cases involving wrongdoing by corporate agents, prosecutors should consider the corporation as well as the responsible individuals as potential criminal targets. So from day one, when I became involved with my company's case, my company was identified by the U.S. Attorney as a target of a criminal investigation. A target is somebody who, if the case were to be presented to a grand jury today, is likely to be indicted. I'd like to talk a little bit about the second prong of that test for respondeat superior, and that is the fact that the conduct needs to be, at least in part, intended to benefit the corporation. The courts have been extremely lax and lenient toward prosecutors in proving or attempting to prove that function, that element. Agents of a corporation can act for mixed reasons, both for self-aggrandizement, such as profit, and also for the benefit of corporation. As long as one of the motivation is to benefit the corporation can be indicted for the conduct of its employee. And the case that says that is the United States versus Potter. It can be found at 463 Federal 3rd. It's a First Circuit case, 2006. And like I said, courts have gone a long way to sustain corporate criminality in mixed motive situations. In the United States versus Automated Medical Laboratories, the courts affirmed the corporation's convictions for the actions of a subsidiary's employee, despite its claim that the employee was acting for its own benefit. That is, and here was the claim that the employee of a subsidiary was acting to benefit his ambitious nature and his desire to ascend the corporate ladder. The employee was, according to the Third Circuit, clearly acting in part to benefit AML, which was the defendant corporation, since his advancement within the corporation depended upon AML's well-being and its lack of difficulties with the FDA. That's kind of stretch. The D.C. Circuit has affirmed convictions of corporations, rejecting a corporation's argument that it should not be held criminally liable for the actions of its vice president, who had a scheme which was designed and did, in fact, defraud the corporation that he worked for. According to the court, the fact that the vice president deceived the corporation and used its money to contribute illegally to a congressional campaign did not preclude a finding that he acted to benefit the corporation. Part of the vice president's job was to cultivate the corporation's relationship with the congressional candidate's brother, who was the Secretary of Agriculture. And the jury was entitled to conclude that the vice president acted with an intent, quote, however befuddled, close quote, to further the interests of his employer. There are cases in which a corporation was indicted, convicted, and the conviction was affirmed because the fraudulent scheme required money to pass through the corporation's treasury, and fraudulent goods were then resold by the corporation, thereby evidencing a benefit to